Hello, everyone. Um, I hope you have already watched all the lecture about Nord Stream and Opal case. This is the second case I'm going to talk about within our course, EU Energy Law and Policy. And if you haven't watched that one, I strongly recommend you to do so because the Nord Stream 2 case actually comes in the following of the Opal and Nord Stream 1 and whatever we talked about that one. And it's really better to first watch the Opal case, and then we can enter to the case, the Nord Stream 2 saga, in order to delve into that one deeper. So, just like the previous lecture, I don't want to start with the law, because if we start directly from directives, articles, and court decision, we are going to miss the bigger picture. And for this case, if you miss the strategic background, you would never really understand why the legal battle became so intense between two parts. So let's begin from the first and from the same point we started before in the Opal case. But now we go one step even further. Uh, If you look at the European Union's energy system, one structural fact has always been there: dependence on imported gas. And historically, a large share of the gas has come from Russia. This is not new. Of course, we are talking within the context before a Russian full-scale invasion of Ukraine in 2020 and the EU's decision for gradual cutting off Russian gas. This is something that has been shaped over decades through infrastructure, contracts, and political decisions. Now, what Nord Stream 1 did, and we already discussed this, was to bypass transit countries, especially Ukraine and Poland, on this Yamal-Europe pipeline, and create a direct route from Russia to Germany. From a technical perspective, it made sense. From a commercial perspective, for Russia and Germany, it made sense. But from a geopolitical perspective, it was already very super controversial. Now, Nord Stream 2 was not a completely new idea. It was essentially an extension, duplication of the same logic of Nord Stream. It aimed to double the capacity, reinforces the same route, and further reduced the role of transit countries. When Nord Stream 2 was proposed, one of the first major legal questions that emerged was this: was the third gas directive applicable to Nord Stream 2, and why? Very similar to the question that we had in the case of Nord Stream 1. If you have followed the Opal case, then it is not difficult to answer this question with a no, because initially the dominant legal interpretation was that the third gas directive does not apply to Nord Stream 2. This is the first logical point I want you to take away from this lecture, obviously. And this interpretation was not just academic. It was supported by the legal service of the Council of the European Union as well. So they came up with a very strong no. Now, this is a very important moment, because at this stage, the European Commission tried to intervene. It didn't like this legal answer, because he wanted to find some ground, some legal ground to intervene and to have its own statement, its own role. But why did the Commission want actually to intervene in this project in the first place? Especially because we didn't see such an intention in Nord Stream 1 in the past. And remember, just a marginal point, that Nord Stream 1 is not a very common term. I'm just using it specifically in this lecture, as I did in the Opal lecture, to make a distinct between Nord Stream 2 and the former Nord Stream, the first pipeline and the second one. But generally, Nord Stream 1 is not known as Nord Stream 1. It is called Nord Stream, very simple. Banking to our main storyline. So here is the key difference. Nord Stream 1 was built in a relatively cooperative environment between Russia and Europe. But Nord Stream 2 was proposed and developed in a completely different political context. I mean, in the growing distrust atmosphere, geopolitical tensions, and increasing concerns about dependency. And what made it more complicated was the fact that Germany wanted to still pretend Nord Stream 2 as a commercial deal, helping its own energy security. But the Commission had a much more skeptical perception of this project, along with more radical perspectives by Poland, by Baltic states, and some Central European member states at that time. And this is where things start to become complicated. The Nord Stream 2 became a battlefield between these two sides, a battlefield between different member states, between EU institutions, between law and politics, and even between the EU and external actors like the United States, as later we will unpack this step by step. So let's go further into the details. First of all, how Commission wanted to intervene. Actually, the Commission requested a mandate from the Council to negotiate an international agreement with Russia that would ensure that Nord Stream 2 operates in line with EU energy law principles. What's a mandate? And this is actually the second legal point I want you to take away from this lecture. Well, a mandate basically means a formal authorization. In EU terms, the Commission cannot just go and negotiate with a third country on its own. It needs permission from the Council. So when the Commission asks for a mandate, it was essentially saying, give me the legal authority to negotiate on behalf of the EU with Russia on this pipeline. Now, why did the Commission do this? The reason was that within the EU procedures, if the EU law does not apply automatically, then you need another legal instrument to impose those rules. And the Commission's idea was to create the instrument through an international agreement. So the Commission argued that there was a risk of what is called a legal void or even a conflict of laws, because part of the pipeline would be outside EU jurisdiction and different legal regimes could apply along its route. So if you look at the map, you'll see that, like the Nord Stream, this pipeline also does not pass through the territory of any EU member state to make it covered by the EU law. And here we mean basically the third energy package. So on June 12, 2017, the Directorate General for Energy, or DG Energy, of the European Commission submitted to the Council of European Union a draft recommendation or a mandate for a decision authorizing the negotiation of an agreement between the EU and Russia on the operation of Nord Stream 2 pipeline in order to ensure coherent regulatory framework contributing to market functioning and security of supply in the Union. If we want to put it more straightforward, it should say that the Commission's position was like We need a coherent regulatory framework to ensure proper functioning of the market and security of supply, and to facilitate our role uh, protecting these EU legal values. We need to be granted the mandate. And at first glance, this could sound reasonable. But here is where the legal service of the Council stepped in, and this is one of the most important legal moments in the whole Nord Stream 2 saga, because the legal service rejected the Commission's argument. What was its argument? It clearly stated that there was no sufficient legal basis for such a mandate. And more importantly, it explicitly argued that the third gas directive does not apply to Nord Stream 2 as such. So we kind of say that asking for a mandate here was a bit negative proposition because the subject itself didn't even exist, legally speaking, ab initio. Now, let's unpack their reasoning because this is where the legal depth comes in. First, they looked, this legal service, they looked at the wording of the directive. The directive is designed to regulate transmission system within the internal market. It does not extend to import pipelines, especially from third countries, And then most specifically, those pipelines in offshore sections. Secondly, they looked at the intention of the legislator. There was no indication that the EU intended to regulate pipelines like Nord Stream 2 when adopting the third energy package. Thirdly, they addressed the Commission's arguments about a legal void because, as I mentioned earlier, the Commission said, I see a legal void here. Give me the mandate. And here, the legal service rejected the existence of any legal void. And it's very interesting. The legal service said, we do not see such a thing. Why? Again, let's get back to the map. If you look at the pipeline map, you'll find out that different parts of the pipeline are already governed by existing legal frameworks. How? The international law, including the law of sea, applies to offshore sections. The national law applies at entry and exit points. And Russia's regulations are applicable to the pipeline on its own territory. So, from their perspective, the system may be fragmented, but it is not legally empty. And then they addressed the idea of conflict of laws. Again, they rejected it. You know why? Because, let's put it simple, when a conflict comes up, there should be some real overlaps between two opposite legal systems. But obviously here, there was not such a thing. Because the EU law does not apply in the first place in the international water and on this section of the pipeline that is lied in the high seas. So there is no conflict, as I already explained, that how different sections of the pipeline are being ruled by the law. So you see the point? In essence, the legal service closed the door to the Commission's approach. Now, think about what this means. We had, on the one side, the Commission trying to extend EU law. On the other side, the Council's legal service saying, legally, you can do that. Now, when law cannot achieve a certain objective directly, what happens? Politics enters the game. So, back into our main storyline, Several member states, especially Poland and Baltic states, together with some of the Central European member states, they were strongly opposed to Nord Stream 2, with stronger reasons compared to their opposition to Nord Stream 1. Their concern was not just legal, it was more strategic, because they argued that Nord Stream 2 would increase Europe's dependence on Russian gas. It reduces the importance of existing transit routes, and it weakens the energy security of Central and Eastern Europe. So instead of trying to stop the project directly, which was difficult, as I explained, they shifted the strategy. What strategy? They paused uh, on the law, and they tried to change the law to something new. But how? This is the point that I'm going to explain deeper. So in order to, you see that the problem was that the law was not applicable to Nord Stream 2. So the idea was that if it's not applicable, we need to amend it somehow that it becomes applicable. You see the point? So the member states tried to extend the jurisdiction of this EU law to somewhere beyond the borders of the European Union. But of course, this was not an easy process because you needed the majority in parliament to amend the law, while there was strong opposition within the European Union itself, especially from countries like Germany, obviously, which supported the project. So, in fact, Germany argued that Nord Stream 2 is a commercial project to me, and that member states have the right to determine their own energy mix under Article 194, paragraph 2 TFEU. And you remember this Article 194. We have had reviewed this article several times in our course and in the Opal case and now here. So you see the point that any measure that wants to actually protect the energy security as a common responsibility of the EU and the member states can be adopted, but at the same time, it is mentioned that such measures shall not affect a member state's right to determine the conditions for exploiting its energy resources, its choice between different energy sources, and general structure of its energy supply without prejudice to Article 192, paragraph 2, subparagraph C. So once again, we see a clash. On one side, integration, regulation, and common rules and strategic interests. On the other side, national sovereignty and energy choices. This debate went on for more than a year, and the outcome was a compromise. In what sense? In a sense that in summer 2019, the EU adopted an amendment to the Gas Directive. Now, what did this amendment actually do? Well, it extended the application of key internal market rules, and you remember these key market rules: unbundling, third-party access, tariff regulations, so on and so forth, to pipelines connecting the EU with third countries. But this is the critical limitation. The extension made it applicable only within the territory and territorial sea of the member states where the pipeline enters the EU. And this is what I said when I was teaching you the fourth energy package, or the winter energy package, or clean energy package. In its natural gas section, obviously. Although it's more accurate to say that the recast that came in 2019 was more like after the original winter energy package. But anyway, we need to get deeper into this to see what it means. And a critical question here comes up. Was the problem solved by this amendment? Because before that, the EU energy package was only applicable to the EU territory. Now they extended it to territorial waters as well. What do you think? And here, like the previous one, I want you to make a pause on this video and think about the legal consequences of this amendment. Did it change the whole story of Nord Stream 2 significantly, or what? So I hope you pause the video for a moment to analyze the situation for yourself. But now let's see what we have here. So you see here a closer view on the pipeline for the Nord Stream 2. The amendment means that only the part enters German territorial water is covered by the EU. So to be more precise, this is German mainland. So the EU energy package before the amendment in 2019 was applicable up to here. But then the 2019 amendment said that to this blockchain blue line, which is the territorial water of Germany, this energy, the third energy package, the third gas directive, and etc., they should be applicable to this tiny part of Nord Stream 2 as well. So now this is actually the part of the line that goes under the jurisdiction of the energy package. But everything beyond that, beyond this blue blockchain, the offshore section, the Russian territory, it remained outside, and it remained the same outside of the EU energy jurisdiction. So again, we end up with a hybrid system. Now, why is it important? Because it creates a very complex regulatory situation. You have one pipeline, but different legal regimes, and they are applying to different part of the pipeline. And this raises practical question. How do you enforce unbundling on only part of the pipeline that is in the territorial waters of Germany? For instance, think about third-party access. You're asking the Nord Stream pipeline operator to grant access to third parties to this section of the pipeline, but you cannot impose your will beyond this part. So somehow this does not make sense because you are actually dealing with one single pipeline. There is no branches to it. Who would want access to only this part, which is in the territorial waters of Germany, when there is no connection anywhere else? You see the logic? Also, one can ask, how do you ensure third-party access in a system where supply is controlled by a single actor? And similarly, another question is that how do you deal with cross-border effects when regulation stops at territorial limits? These are not easy questions, and the amendment did not fully resolve them. So it simply shifted the problem. Now, at the same time, this amendment had a very clear political dimension. It was widely understood that this was an ad hoc measure designed specifically for Nord Stream 2. And this is important to understand because it shows that EU energy law is not always neutral, is not always purely technical, something that is sometimes shaped in response to very specific projects. And this is actually the third legal point I want you to take away from this lecture. So, was this the last legal issue with Nord Stream 2? No, it was not. Another issue, which I would say was one of the most interesting legal and regulatory challenges in the Nord Stream 2 project, relates to the routing of the pipeline near Danish island of Bornholm. Now, at first glance, this might look like a purely technical or environmental issue, but in reality, it raises an important legal question under international law, particularly the law of sea. Well, we will have an independent lecture about law of the sea, but for now, we need to have a glance on this topic very briefly. And for this reason, let me go to have a quick glance on the UNCLOS. All right, so here the key idea is that to keep in mind for now, we have a famous convention called United Nations Convention on the Law of the Sea, or UNCLOS. Stands for United Nations Convention Law of the Sea. And the UNCLOS divides the sea by distance from the sea line of the littoral states, as you can see here in this hypothetical map. So we have territorial water, territorial sea, contiguous zone, exclusive economic zone, and international water. The legal regime for line pipeline is completely different depending on whether a pipeline crosses the territorial sea or exclusive economic zone, stands as EEZ, or continental shelf. But in a nutshell, in the territorial sea, Article 2 of UNCLOS tells us that the coastal state has sovereignty, full sovereignty, over the waters, the seabed, and the subsoil. There is no equivalent to the freedom to lay pipelines. So, legally speaking, a coastal state can simply say to other states, request for laying down pipelines, that no, you're not laying a pipeline here, full stop. That's all. By contrast, once you move into the EEZ and continental shelf, Article 56, 58, and especially later Article 79 of the UNCLOS kick in. And Article 79, paragraph 1, recognizes the right of all states to lay submarine pipelines. And 79, paragraph 2, says the coastal state may not impede that right outright. However, the same article, paragraph 3, makes this clear. The route still requires the coastal state's consent, and it can impose conditions for environmental protection and resource management. So to wrap it up here, and this is the message that I want you to take from this slide. If I am a littoral state in my territorial water, 12 nautical miles from my sea line, I can totally say no to any pipeline request, any third country who wants to lie down the pipeline in my territorial water. I say no, it's not possible. You know, it's my sovereignty. But beyond that, especially in the exclusive economic zone, I cannot say no, but I have something, some rights over the route. I can say, you know, you cannot lie down your pipeline from this route that you want to do because of environmental consideration, because of resource consideration that I want to have access to, or something like this. So I cannot fully reject the request in the EEZ, exclusive economic zone, but I have some rights over the route, right? So I have some time, of course, some time limit to announce my decision on this. It's not like I postpone it forever. At the end of the day, I need to come up with some ideas. And that matters for us in the case of Nord Stream 2. Why? Because the original plan of Nord Stream 2, this red blockchain pipeline route, in 2017, when Russia wanted to lay down the pipeline, the original plan was to route the pipeline through Denmark's territorial water near Bornholm, similar to what Nord Stream 1 did. As you can see, Nord Stream 1, the yellow line, passes through the territorial waters of this island, which belongs to Denmark. Here it is. This is the line I mean. That's legally the most sensitive option, because here Denmark would have had full discretion to approve or reject the pipeline request, as I explained. So what makes it more interesting here to discuss is that around the same time, Denmark, 2017, Denmark amended its domestic law to explicitly allow denial of such projects on foreign policy and security grounds, not just environmental one. So when Russia wanted to lie down the pipeline in the territorial water, it became impossible for it. But once it wanted to apply for EEZ area, the part that here you can see, as it has crossed finally something between the gray line and the blockchain blue line, it wanted to apply and it asked the permission from Denmark. But at the same time, Denmark decided to make its law even stricter somehow, to have more power to say something about rerouting and asking Russia and Gazprom to change the route of this pipeline, not only based on environmental consideration, but also based on security consideration. So even though UNCLOS, the United Nations Convention Law of the Sea, already gave Denmark strong control in its territorial sea, this move made the political dimension very explicit. What happened next is a classic example of law shaping geopolitics. Denmark didn't outright reject the project, but it delayed the process and pushed for alternative routes. What do I mean? Nord Stream 2 wanted to have this route, but then its request was delayed to receive the reply. So the company responded by proposing another route outside Danish territorial water in the special economic zone. And once the project shifted into that legal zone, Denmark's power were narrower under Article 79 of UNCLOS. Why? Because, as I said, it could not just block the pipeline entirely, but it could influence the route and impose conditions. So in 2019, Denmark finally granted a permit for a route southeast of Bornholm, outside its territorial sea. And this is what you can see here. Nord Stream 2's routes differ around Bornholm compared to the older pipeline, the yellow one. So in short, the legal distinction in UNCLOS between territorial sea and EEZ wasn't just theoretical. It directly determined the outcome of the project. And actually, in this sense, in the case of Nord Stream 2, it was further delay. And this is the fourth point I want you to take away from this lecture, how this UNCLOS actually played a role here in the case of Nord Stream 2. So that was not the last moment and the last development in Nord Stream 2. Let's zoom out from the project a bit more, because while all this was happening inside the EU, external pressure was also increasing. And this brings our story to the role of United States. The US strongly opposed Nord Stream 2, arguing that it would increase Europe's dependence on Russian gas and it undermines Ukraine, and it is basically against what the values of Europe's security are. But the US did not stop at political statements, as it introduced sanctions. And these sanctions against Nord Stream 2 and those companies, targeted companies involved in the construction of pipeline, actually had adverse influence on the progress of this project. Now, why I'm bringing this story of sanction? Because from a legal perspective, this is highly controversial, because these are what we call extraterritorial sanctions. The US was effectively imposing restrictions on non-US companies for activities that take place outside US territory. So the question was this action by the US legal? Well, under international law, this is debatable. Some argue that states have the right to regulate conduct that affects their interests. Others argue that this violates the principles of sovereignty and non-intervention. This is the matter that we discuss in another course that I have. And here we don't want to get into the details of this. But I want to give this message that legality is not clear-cut here. But there is another dimension, that is the legitimacy. Because even if something is legally questionable, it may still be seen as politically justified, right? So the US framed these sanctions as a way to protect European energy security and support Ukraine and to stop Russia of weaponizing its gas. Critics, however, argued that this was also about promoting US LNG export to Europe. Well, this is also something noteworthy. So again, we see this duality, law versus politics, legality versus legitimacy. And this is the fifth point I want you to take away from this lecture, because Nord Stream 2 sits right in the middle of this duality. Now, all of these developments, legal disputes, legislative changes, political conflicts, sanctions, they created a highly uncertain environment for the project. But despite all this, construction continued, and eventually the pipeline was physically completed. But that did not mean it could start operating. Why? Because the final hurdle was still there, and that was certification. And this is where we move into the next phase of the story, because now the question is no longer about building the pipeline and the route and the jurisdiction and all the things that we have passed through. It is about whether it can legally operate within the EU framework. So at this stage, Nord Stream 2 is physically completed. The pipes are there. The infrastructure is ready. The investment has already been made. But under EU law, that is not enough. Before any pipeline can start operating, it must go through a certification process. This is something that we discussed under third energy package in particular, right? The certification and how actually NRA has the right. Because this certification must be granted actually by the National Regulatory Authority, or the NRA. And in this case, You know who is the NRA if you have watched the Opel case. It was German Bundesnetzagentur, and it must comply with EU energy law, particularly the rules on unbundling. Now, let's pause here for a second and recall what unbundling actually means, right? The idea of unbundling is that the company operating the transmission network must be independent from the company supplying the gas. This is meant to prevent conflicts of interest and ensure fair access to the network. But in the case of Nord Stream 2, this became immediately problematic. Why? Because the pipeline was owned and controlled by Nord Stream 2 AG, which is a company based in Switzerland, but ultimately fully controlled by Gazprom. So effectively, the supplier, Russia and Gazprom, and the pipeline operator, the Nord Stream 2 AG, are the same entity. And this is exactly what EU law tries to prevent, right? This is what we discussed extensively in our course. So the question becomes, can Nord Stream 2 be certified under EU law in this structure? Now, different legal options were considered. One option was ownership unbundling, meaning that Gazprom would have to give up control over the pipeline operator. And you know this model of ownership unbundling, we discussed about that. Another option was what we call as the independent system operator model, the ISO. Again, you remember this from our lecture about third energy package, where the infrastructure remains owned by the same entity, but operation is separated. But none of these solutions were straightforward. Why? Because in practice, they would require significant restructuring of the project. So what did Nord Stream 2 AG do, the company? It tried to adopt. So on November 16, 2021, the Bundesnetzagentur paused the certification process, stating that certifying a Swiss registered company as an operator was not possible under German law. And on January 26, 2022, a German subsidiary was created to act as the operator of German section of the pipeline in order to comply with EU requirements. Now, the German NRA started the certification process, but then it suspended it. Why? Because it argued that the company structure did not yet comply with the legal requirements under German law implementing the EU directive. So certification was put on hold after all this long wait that Nord Stream 2 survived to be built, to be registered, and to apply for the certification. Now, here you can see how complex the situation became, because legal compliance was not achieved, and because of this, the pipeline could not start operation. And then it became even more complicated because while the process was ongoing, the European Commission also had a role. Because under EU law, the Commission must review the certification decision to ensure that it complies with EU energy rules. So we have a multi-level process. The national regulator of Germany, the Bundesnetzagentur, in the NRA, the European Commission, and potentially judicial review. You remember the energy solidarity principle, and here you find the reason that why I told you that it's highly recommended watching the Opel case at first to understand what energy solidarity is. So according to this energy solidarity, if you want to have a project, then it means that you need to evaluate the effect of your project on other member states' energy security level. Because EU's energy security should be met in the spirit of solidarity. And this is the energy solidarity principle meaning, right? Now, the problem was that all of this was happening in a highly politicized environment. And then in early 2022, everything changed. You know why. Germany suspended the certification process because of the escalation of conflicts between Russia and Ukraine. And at that point, the German government decided officially not to proceed with the certification of Nord Stream 2. So effectively, the project was stopped at the final stage. Now, this is very important moment because after years of legal debates, all the political difficulties, regulatory adjustments, development of energy packages, and that 2019 amendments, and all these political conflicts, the final decision was not purely legal. And this tells us something very important about the limits of law when we talk especially about EU energy law. Now, shortly after that, another major event occurred. So, in September 2022, explosions damaged Nord Stream 1 and Nord Stream 2 pipelines in the Baltic Sea. And now again, I'm not going to speculate about responsibility, but from a legal and analytical perspective, this event is extremely significant because it effectively removed the infrastructure from oppression. So all the legal debates about access, certification, and regulation suddenly became, in a sense, secondary because the pipeline could not even physically be operational. Now, let's take a step back and think about what we have seen so far. We started with a strategic infrastructure project. We moved into a legal debate about applicability of EU law. We saw institutional conflicts between the EU Commission and the Council's legal service. We saw legislative change through the amendment of the Gas Directive. We saw external pressure through US sanction. We saw regulatory changes in certification. And finally, political decisions and physical events, the explosion that stopped the project. So to wrap it up properly, I pose this question to you. What does all of this tell us? Well, in response, I guess one can say it tells us that EU energy law operates in a very complex environment. It is not just about rules. It is about how those rules interact with national interests, with geopolitical tensions, together with market structures and also external actors. You could see the footprint of external actors here, at least in two significant stages. Now, one final point I want to emphasize before we move to the conclusion. If you compare Nord Stream 1 and Nord Stream 2, you see a very clear shift. Nord Stream 1 was built in a relatively stable environment. Nord Stream 2 was built in a contested environment. And this difference explains why the legal treatment of the two projects is so different. And understanding that context is essential if you want to truly understand cases like Nord Stream 2. And with that, now we can properly conclude this case. Thank you for your attention. I hope you have found this case and this Nord Stream 2 story insightful for you. So you see that these two cases are very overwhelmed, fully detailed, legal, political, geopolitical, technical, aspects of energy all in one sense. And in one case, well, I consider Nord Stream 1 and 2 very much connected and can be wrapped up in one case. And for this reason, I picked these two cases to discuss with you, and then you can have this video to review it if you want several times. And you are always welcome to write to me if there is any question, or we can discuss later about the case and your question if there is any. Thank you again, and have a good time.